Following the publicity of the upper tribunal's decision in the Wilkes high income child benefit charge case, we've been absolutely inundated with requests for help from other taxpayers. To everyone who has got in touch with us, I want to say thank you. We've taken your contact details where you've allowed us to, and we will stay in touch with you. We'll also issue updates like this on our website at collierbristow.com. We said when the upper tribunal's decision in the Wilkes case was released that HMRC had until the end of July to decide whether to seek leave to make an appeal to the Court of Appeal against the upper tribunal's decision. It has made that application and leave has been given, so the Wilkes case will be heard on appeal again in the Court of Appeal in the coming months. And we will be delighted to continue acting pro bono for Jason and Samantha Wilkes in that case. Most people who have got in touch with us have asked how the Wilkes decision can help them personally. And one of the notable features of HICBC is how powerful the strength of feeling is among taxpayers affected by the charge. And we've been struck by that. The first thing to say is what Wilkes did not do. It did not overturn HICBC, and as HMRC has commented in its press releases, the HICBC remains payable. So anyone subject to it must continue to make their filings with HMRC accordingly and must pay the charge. Questions about the future of the HICBC are for the Treasury, and there have been wide-ranging calls for the abolition or reform of the charge, including recently from the Office of Tax Simplification. We think that, as any fair-minded observer would agree, both the policy and the implementation of HICBC have been a conspicuous failure, as in fact the government was warned when it first introduced the idea to Parliament. So the Wilkes case was on a narrow technical point, which is that HMRC has no power to issue discovery assessments under Section 29 of the Taxes Management Act 1970 for the HICBC or for certain other freestanding tax charges where the taxpayer had not filed a self-assessment tax return. The common feature of most HICBC cases is that taxpayers had failed to submit their self-assessment tax returns, not because they were deliberately evading the tax charge, but because they simply didn't know about it. The Wilkes case only applies to taxpayers in that position. Those who received a Section 29 discovery assessment in circumstances where they had not filed a self-assessment tax return with HMRC to declare their liability for the HICBC. Affected taxpayers fall into two broad groups. First, those who've received HICBC discovery assessments recently, within the last 30 days, and secondly, those who received them more than 30 days ago and so are out of time to appeal them. Dealing first with those who have current assessments, all those who have received HICBC discovery assessments within the last 30 days should appeal them straight away. They should cite the upper tribunal's binding decision in the Wilkes case, and they should refer to the case by name. The first step is to lodge an appeal with HMRC, and there are no particular formalities for that. The appeal must be in writing. It must state, or at least make clear, that it is an appeal against a tax assessment, and it should identify the relevant assessment. And it must be addressed to the Revenue Officer who issued the assessments. If, as I expect it will, HMRC rejects the appeal, then the taxpayer should lodge an appeal with the first tier tribunal. The appeal form can be found online, and it's relatively simple to fill in. You should briefly explain the situation. You don't need to use legal language. Again, you should refer to the Wilkes case by name, and you should ask for the same outcome to be applied in your case. All appeals of this type will be stayed, which is to say paused, behind the Wilkes appeal. Dealing now with the second group, which is to say those who have historic HICBC assessments, They're now out of time to make an appeal to HMRC. However, subject to certain rules, it is possible to make a late appeal. In my view, the clarification of the law in the Wilkes case is sufficient justification for a late appeal. For both groups of taxpayers, everything is dependent on the outcome of the further appeal in Wilkes. Of course, in litigation, no outcome is assured. But with comprehensive decisions in our favour from the first tier tribunal and the upper tribunal, we will go to the Court of Appeal confident of our position and the strength of our arguments. My current view is that taxpayers who are out of time to lodge an appeal against HICBC assessments have nothing to gain by seeking to do so now until the outcome of the Court of Appeal's decision is known. I think it would be prudent and reasonable to await the Court of Appeal's judgment before deciding how to proceed. And this is particularly the case because if we are successful, much will depend on HMRC's reaction. As I see it, HMRC would have 4 options as follows. First, they could seek a third appeal to the Supreme Court, though I think it seems improbable that this would be allowed. Second, it could voluntarily approach affected taxpayers to rectify its procedural mistake, probably with the repayment of the HICBC charge for some tax years, and here I'm thinking particularly of the years between 2012 and 2016. Thirdly, it could do nothing. Fourthly, and most controversially, it could try to bring forward retrospective legislation in Parliament to cure the defect identified by the Wilkes case. In parallel with our preparations for the Court of Appeal hearing, we're making plans for all of those eventualities. When the time comes, and if we're successful again in the Court of Appeal, we'll be liaising with our counterparts at HMRC and, if necessary, with the tribunals, with a view to ensuring that all relevant taxpayers will be able to have the benefit of the Wilkes case. Finally, if you think this issue affects you and you haven't already done so, please do get in touch with us via our website at collierbristow.com and leave your contact details. We will issue further updates like this whenever we're able to do so. But as I hope I've already made clear, it's too soon for us to be able to act for other taxpayers at the moment, and we will be in touch if and when that situation changes. Thank you.